Good evening, everybody. The Irish Demon here, back with another video. I'm making great time here, being back in the studio. It is such a relief to be back. I'm absolutely delighted to be able to actually be back in I say my studio, my office. Really, it's an office I'm working out of now, and it is great to be back. I have a pretty horrible one here today. This old boy. The story is pretty horrible. The things that he did to young people, if you get me. And he's back for resentencing. He gets a bit of time added on, quite a bit of time added on. Let me know in the comment section down below. Do you think that just jail time is enough for people like this? I debate with myself, and I kind of don't know sometimes. It's hard to say. But you won't believe some of the things that are said in this. This man is beyond heartless. He's in here begging for mercy, and he doesn't get it, though. So I'll kind of give you that bit of relief at the start. But this is going to make you angry. Let me know in the comment section as we go along what you think of some of the things that are said here. It's quite something. Now, I don't know where I'm going to end up on the screen during this whole thing. I'll have to kind of move around. I'll go off screen from time to time and leave it play out. And I'll probably take a couple of breaks here and there to make some comments. So we'll just play it and kind of see how we go. I think I need to make myself smaller. Hold on, because I'm kind of taking up most of the screen there. But here we go. Check this out. This is nasty stuff.
All right, good morning. We are on the record in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access both in the courtroom and also online. And we're here this morning for a resentencing in People of the State of Michigan versus Randall Newman II. It's filed 2020-5914 FC. Counsel, you want to state your appearance beginning with people?
Melissa Goodrich, Sheboygan County Prosecutor.
Good morning, Judge Kira Scott, State Appellate Defender Office. I'm joined by Mr. Noonan to my right and co-counsel Garrett Berg.
Okay, good morning. All right, so this was remanded from the Court of Appeals on a direct appeal by right, confirming the convictions, but remanding for resentencing because it found that I erred by imposing consecutive sentencing. So because it is a resentencing, I think all sentencing issues are open, so we need to reestablish certain things. But before we get into that, Ms. Scott, have you had a chance to review the pre-sentence, the updated pre-sentence report and recommendations with your client?
I have, Judge.
Do you have any additions, corrections, or modifications requested to the factual information in that report?
No, Judge.
Ms. Goodrich, to the people?
No, Your Honor.
Yeah, Ms. Scott, does the defense have any scoring challenges?
No, Judge.
Ms. Goodrich, do the people have any scoring challenges?
No, Your Honor.
I had a couple I wanted to address and get input from counsel then. OV11 was scored at 50 points on the resentencing, and
I didn't realize it. I thought it was still, it remained scored at 0 last time.
no, the scoring has changed. OV11 has been scored at 50 rather than 0, resulting in OV13 being scored at 25 rather than 50.
We would object to that. I apologize.
Okay, and my thought was that OV11 being scored at 50 for other penetrations arising out of the sentencing offense would directly conflict with the remand if there was not grounds for consecutive sentencing. Then there certainly wouldn't be grounds for scoring OV11.
Yes.
Ms. Goodrich, do you have any input on that question?
Your Honor, I don't believe OV11 requires it to be on the same night like consecutive sentencing did.
Well, I think the case law does require it to be part of the same transaction and occurrence and not part of a prolonged course of conduct. So based upon that, and frankly, at the original sentencing, maybe I could have scored it that way on my belief for consecutive sentencing that the record was sufficient to show that some of these penetrations happened at the same, as part of the same transaction or occurrence. But the Court of Appeals found that there was insufficient evidence of that. So I think that I would be compelled on the case law to score OV 11 at 0 points on both counts. So I will do that. And then OV 13, I think originally had been scored at 50 points, but because the OV 11 was scored at 50, the agent reduced OV 13 to 25, but I do think there's sufficient evidence based on the trial record for OV 13 to be scored at 50 points because the sentencing offense was part of a pattern of felonious criminal activity involving 3 or more sexual penetrations against a person less than 13 years of age, and the sentencing offense is first-degree criminal sexual conduct. And the victim at trial testified about penetrations not only of her, but of other siblings. So at the original sentencing, I granted the prosecutor's scoring challenges and scored it at 50 rather than 25. Mr. Burton, it would be my intent to do the same this time.
Your Honor, I'd object to that argument.
Okay. All right. So Ms. Goodrich, you agree with OB 11 being at 0. That I know you're not agreeing to that, but that being the case, that OB 13 should be 50 rather than 25.
Yeah, sure.
Okay. So I'm going to score OB 11 at 0 and OB 13 at 50. And that reduces the OV level from 110 to 85 and the OV level from 6 to 5, reducing the guidelines range from the 225 to 562 or life back to the original 171 to 427. Any objection to that? I guess just arithmetic calculation, Mr. Burton?
No.
Ms. Goodrich?
No objection.
Okay, so the advisory guidelines being revised to 171 to 427 months. Okay. Because this was a jury trial, the habitual offender status, it's a habitual third. That was not established by any plea. And so at the original sentencing, I found that that was established by the uncontested information in the pre-sentence report from a 1998 home invasion second degree in the Flint Circuit Court and a 1998 UDA in the Flint Circuit Court as well. Does the defense have any challenge to the habitual status based on those facts?
No.
Ms. Goodrich?
No, Your Honor.
All right, so the habitual, I'll make a finding that the existence of the prior convictions supports and confirms the habitual third status. So therefore, I'll use the habitual third sentencing guidelines for the recommended range for the appropriately scored guidelines. And also there was a claim for $1,499.19 recommended in the PSIR for extradition costs. At the original sentencing, the defense did not object or request a restitution hearing. But of course, this being a resentencing, all issues are back open. Does the defense have any objection or request a hearing on that?
No objection, Judge.
Ms. Goodrich, any objection to that amount?
No objection.
All right. All right, and perhaps before we get into allocution for the sentence itself, in reviewing, I did have an opportunity to review a sentencing memo and supporting materials submitted by defense counsel. And it looked like there were some legal issues that defense wanted to argue about the imposition of sex offender registration and lifetime electronic monitoring.
Yes,
It might make
Judge.
sense to address that first. So I guess one at a time, if you want to address the SORA challenge.
Yes, Judge. We are just asking to preserve it and would rest on our briefing in terms of SORA.
Okay, Ms. Goodrich, any response from the people?
Your Honor, I just asked that the court follow the law as it stands.
Okay, so the defense argues that requiring 2021 SORA registration of this defendant constitutes cruel or unusual punishment under the Michigan Constitution, and acknowledges that the existing binding case law in this court, People v. Kaczynski, docket 364957 from October 28, 2024, the Court of Appeals held that 2021 SORA is not punishment as applied to sex offenders. So therefore, I would hold that defendant is subject to 2021 SORA And I note in the pre-sentence report that that SORA registration has already been completed. And that issue is preserved for a second appeal by right. And then Ms. Scott, as to lifetime electronic monitoring.
Yes, Judge, we asked that that issue be preserved and again, rest on our briefing.
Okay, Ms. Goodrich, any input from the prosecutor?
Again, Your Honor, I ask that you follow the law as it stands.
All right, so the defense argues that requiring lifetime electronic monitoring without an individualized assessment of risk and no means of petitioning for cessation constitutes cruel and or unusual punishment under both the U.S. and Michigan constitutions. I'm aware that the Supreme Court, Michigan Supreme Court is currently considering that issue. They've heard oral argument once. I think they've invited additional briefing. One of the cases they've done that on is actually one of my cases out of Presque County. I note that in People v. Halleck, 310 Mishat 555 in 2015, reversed in part on other grounds, held that lifetime electronic monitoring for CSE 2 offenders where a victim was under 13 was not cruel or unusual punishment. And the Michigan Court of Appeals in People v. Cunningham issued January 15th of this year, an unpublished case, docket 366138, held that lifetime electronic monitoring for CSE 1 was not cruel or unusual punishment. I do find that reasoning persuasive and agree that lifetime electronic monitoring is not disproportionately harsh punishment given the gravity of these crimes. Defense also argues that lifetime electronic monitoring constitutes an unreasonable search, relying on some out-of-state cases. But in People v. Stansberry, an unpublished Court of Appeals decision issued just this May 21st of this year, held that lifetime electronic monitoring is not an unreasonable search, given the strong public interest in punishing and deterring sexual offenders and protecting society from further sexual violence, and in light of the diminished expectations of privacy of a parolee. So therefore, I also find Stansberry to be persuasive and agree that lifetime electronic monitoring is not an unreasonable search. And both of those legal challenges to the imposition of lifetime electronic monitoring are preserved for appeal by right. And but I will order that this defendant be subject to lifetime electronic monitoring. All right, so let me see if I've gotten through the legal issues that are covered here. There is a mandatory minimum of 25 years in this case because the jury made the requisite findings beyond a reasonable doubt that the defendant was 17 years or older and the victim was under 13. So under 750.520B2B, the penalty is imprisonment for life for any term of years, but not less than 25 years. All right, so Ms. Scott, any allocution defense wishes to make in behalf of Mr. Newman?
I'm actually going to go ahead and make it, Your
Okay,
Honor.
go ahead, Mr.
So as you know, my office and I prepared a very thorough sentencing memorandum for you to review, and I don't want to belabor that memorandum. I do want to bring a couple of points to your attention. First, you know, I imagine when you sentenced Mr. Newman the first time, you took his behavior in your courtroom into consideration, both the behavior that preceded trial and his behavior during trial. And we recognize that that behavior was to some degree unbecoming. I think
I wonder what the behavior was. I'll see if I can find out. If anybody in the side chat or in the comment section or whatever knows, do let me know because I don't really know what that's about.
Mr. Newman's actions, you know, stemmed in part from his frustration with his trial attorneys. Now you've already made that finding earlier in this proceeding that they were ineffective, and we recognize that you know, their ineffectiveness did not make an impact on the outcome of his proceeding in your estimation. But Mr. Newman couldn't have known that at the time. You know, all he understood was that his attorneys were coming up short. And I think anyone in his position would have felt frustrated. And unfortunately, he let that frustration get the best of him. Since his trial, he's had several opportunities to appear in front of him. And during each of those opportunities, he has conducted himself the way that I think that he should. You know, he's followed the rules, he's kept quiet, he has done everything that is expected. I think his behavior in these several subsequent proceedings is evidence of some of the growth that he's experienced while he's been in the Department of Corrections. He has acted, I think, completely differently, and I think for the better. Mr. Newman's progress in the MDOC sort of further underscores the progress that he's made generally. He's gotten just one ticket in the last year, and he's earned his GED and several certificates. He's even learning sign language. He is, I think, making real strides. That's especially true with regard to his mental health. He has started taking his medication regularly, and I think he's recognized that that's something necessary for him to get back on track. One thing that I do want to talk about from the sentencing memorandum is something that Mr. Newman said. A mitigation specialist at my office quoted Mr. Newman in context of him talking about his mental health. She said, "Randall said he understands that managing his mental health is a matter of having the right medication and having the right support system in place to be able to deal with it. For Randall, that means having a counselor he can talk to, a small group of family and friends, and whenever possible, a walk in the woods. Randall is currently seeing a counselor every 3 months as permitted, but he'd prefer to have more frequent sessions. And he also attends group sessions organized by the National Lifers of America." So I think what that says to me is that Mr. Newman is really trying his best to make the most of his time in the Department of Corrections so that when he is released, at whatever point, he is able to successfully reintegrate into our community. That is especially impressive because of his tumultuous upbringing. You know, he has suffered an immeasurable amount of loss from his relationship with his mother and his father and his younger siblings to the death of his child several years ago. All of this, I think, would leave someone scarred and broken and really disinterested in carrying on. But Mr. Newman hasn't let that happen. And for that reason, you know, we're asking for you to impose the mandatory minimum sentence.
All right, thank you, Mr. Burke. Mr. Newman, it is not required that you would make a statement today. If you choose not to do so, I don't hold that against you in any way. However, you are allowed to make any statement you wish today. Is there any statement you wish to make, sir?
I'll let my attorney read the statement.
Okay, that's fine.
His attorney kind of looks like, you know, in Little Britain, the computer says no, lady. Just saying.
And for that reason, you know, we're asking for you to impose the mandatory minimum sentence.
All right, thank you, Mr. Burke. Mr. Newman, it is not required that you would make a statement today. If you choose not to do so, I don't hold that against you in any way. However, you are allowed to make any statement you wish today. Is there any statement you wish to make, sir?
I'll let my attorney read the statement.
Okay, that's fine.
I would like to start off by offering an apology to the court. When I was going through the trial process, my behavior was out of line. I sincerely apologize. I apologize to my attorneys and to you, Your Honor, for my lack of respect for the law and the courtroom. I was so frustrated and angry about being in that situation. You all were only doing your jobs as public servants, and I had no right to disrespect any of you. I know my behavior was wrong. My defensiveness is a character defect that I've been working on in prison. But also like to say that I'm deeply sorry about the things that have happened to my daughter, Aurora. Very sad about everything that has happened. If I could go back in time.
Wait a minute. What do you mean you're deeply sorry about the things that has happened to her? Don't you mean the things that you did to her? There's a big difference there. That's like one of those "I'm sorry that you feel that way" kind of things. Like that's a fucking cop out if ever I heard.
In time to change the past and protect her better, I would do it. Being in prison has given me an opportunity to reflect on mistakes I've made in the past. Even though I don't qualify for many classes through MDOC, I've been working on getting a handle on my emotions through a correspondence course on anger management. I had many times in my past when I believed I could handle my bipolar disorder without taking medication. Now I understand that this is never a good idea. In the future, I promise to always use the tools I know I need to be a healthy person. For me, that means taking my medication and having support people to talk to. Either a
Hang
counselor,
on, can you pause for a second? I think there's something that DOC needs to address with Mr. Newman. We all set? Okay, if you need to interrupt for any security related reason, that's no problem. Okay, go ahead, continue. Mr.
What was that about?
either a counselor, a friend, or a family member. I've also learned that what's best for me is to live a quiet life and to spend as much time as I can outside in nature. I promise you that I will not be breaking the law anymore. Your Honor, I have in the past been a productive member of society, and I can be that person again if given the opportunity. I ask for your mercy and your understanding in my case. I hope you can find it in your heart to give me an opportunity to go home, get the help I need, and get my life on track. In closing, Your Honor, I am sorry. Please accept my apology as you consider my sentence. Thank you.
Thank you, Mr. Newman. Ms. Goodrich,
Your Honor, we have a representative of the victim that would like to speak.
is this the adoptive mother again?
Yes.
Okay, you're certainly welcome to make any statement you wish today. I do want to let you know that I did review the statement at the original sentencing and would take judicial
is where it
notice
gets
of that
really
statement,
interesting.
which I thought was very graceful and very powerful. If it's difficult for you today to make a statement, you want to rely on that, that would be fine. If you want to make a statement today, you're more than welcome to do so. Okay, go ahead and come on forward.
Thank you, Your Honor. First, I have to go off script because in light of his own statement and that of his lawyer, shallow apologies and putting a timeline on the amount of time that he has to pay for what he's done when my children, because multiple victims, only one is listed, but multiple victims have no timeline on their therapy, on PTSD and what that does to children that was inflicted on them. To hear him say that my childhood and the pain from my parents or losing a child, I've had loss in my life and I didn't go off on crime sprees, or to apologize and blame frustration for the way you act in a courtroom. Imagine what other people in the courtroom are feeling. And I sat there and listened as his incompetent lawyer made excuse after excuse. He looked at me, he winked at me, he smiled.
Oh, shots fired. Sorry, I got to go back because I literally did what I always do, which was interrupt right at the juicy bit. Wait till you hear the kind of stuff he was doing. Like, he's all like apologetic. Well, it's not even, he didn't really even apologize, but like, whatever. He's trying to appear to be apologetic, but hear the stuff that he was doing behind the scenes.
Other people in the courtroom are feeling. And I sat there and listened as his incompetent lawyer made excuse after excuse. He looked at me, he winked at me, he smiled at my husband. There's zero excuse for that. But now back on script. I am a Christian and I do believe in grace and forgiveness. But today I'm not asking once again for grace or forgiveness or mercy, I should say, for you to show mercy or this court to show mercy to a man who destroyed children. Mercy is between a sinner and God, and Your Honor, your job is not to show mercy. Your job is very different because it is to provide justice. That's what you are elected for, and it is to protect children. Randall Newman shouldn't even have the right to sit here today and ask for resentencing. Yet I'm glad, frankly, that we live in America and we have rules in court of order and court of appeals because sometimes it's needed. And yet here we are again, though, another moment where he twists the law for his own selfish purposes with no regard for the people his actions affect most, which are innocent children. Winning an appeal on a technicality doesn't make what he did any less monstrous. It only wastes taxpayer dollars, which, now we're paying for his GED and his other learning sign language, drains the time of this court, and frankly forces us to relive pain. It causes.
I really like this lady a lot. She's so sorry. No, I shouldn't really be interrupting it now, but like, she is so powerful in what she's saying here, and making it very clear what she expects. And she's right. I respect that she's like not, saying that, oh, he should just be locked up immediately and that's it. She acknowledges and respects the fact that there is the rule of law. There's a way that we do things in the Western world for a reason. So I really, really respect that. She's right. Like, the amount of taxpayers' money being wasted on this absolute piece of garbage is I can only imagine, astronomical at this point. But you know, that's the way our system works. That's what we kind of sign up for. But yeah, no, good on her. She's doing a great job the way she's talking here.
His GED and his other learning sign language drains the time of this court and frankly forces us to relive pain. It causes anxiety and trauma all over again, and it only further confirms that his punishment is appropriate to his crimes. When my daughter, who was named as the official victim, and her 3 younger siblings came to our home, they were wounded and broken. They had already been shuffled through foster placement, separated into 2 different homes, and stripped of the stability that siblings should never lose in the first place. They carried fear, confusion, and griefs from lives torn apart. We were told to pick new names for them the day they arrived, both because the threats Randall and Jessica posed and because their therapist felt that it would be helpful for the oldest to start fresh. Stripping all identity away is not a way for a family to start.
Absolutely.
That is the aftermath of complete destruction. In our home, for the first time, they were reunited, held in safe space, and allowed to just be children again. Because of Randall, my children were robbed of childhoods. Every day in those early years were structured around healing, trauma therapy, play therapy, bonding therapy, speech therapy, occupational therapy, special education supports. All of this became our life, and frankly, today still is. For years, our calendar was filled with appointments, long drives, and the hard work of recovery. We missed vacations, family gatherings, and everyday moments, all sacrificed so the children could begin to heal. It isn't over. My oldest, now 12, still wakes from nightmares. I have 2 children that still wet their beds at 8 and 7 years old. The child he raped continues to struggle with severe trauma and anxiety and remains in therapy. She has to go to bonding therapy still, and once a month, because her therapist thought it was advisable, she goes to therapy just to learn to be in society, to make friends. The other children who never saw their
That's
date in court
heartbreaking.
still carry scars, one with learning challenges from prenatal substance exposure. These aren't things that I'm making up. They're documented by court, they're documented in Child Protective Services and with doctors. Another with multiple diagnoses requiring ongoing intervention. The damage is real and the damage is lifelong.
Mm-hmm.
2 of his victims have a clinical diagnosis of PTSD, and that will not end in 20 years if you choose to release him. He has shown no remorse.
None. That's the thing.
His letter today, everyone can hear it for what it is. He lied in court about the ages of his children that he was supposed to protect. His lawyer produced no defense witnesses because there was no defense for his action. He manipulated legal processes to stall the children's permanency. What should have taken 6 months for an adoption took 3.5 years.
Wow.
He did not do it out of love or preserve a family. He did it to keep control of children that he saw as possessions. Every delay and every appeal and every twisted tactic served only to his selfishness and never for that of the children. Today, those children share my name. They are safe and they are surrounded by love and stability in a community that cherishes them. Their legal documents reflect that fact, and I want him to hear that. His name is no longer on their birth certificate because their birth certificate has my husband's name as their father and my
He doesn't
own name as
deserve
their
to be
mother.
on it,
Even
frankly.
the government has replaced the records that once bound them to him.
Good.
Every day we parent, we teach, and we protect these children is another day his identity in their lives fades. Every day is a victory. By the time my children are adults, the only trace that he will have left on them is his DNA. Nothing else. No control, no legacy, and no place in their future. I will not retell the worst details of what he did because I refuse to hand this sick man a script for his dark, sick, and twisted mind to relish. What I will say is this: he should spend the rest of his life in confinement. I hope his permanent residency is in a cell no larger than my bathroom. While my children live with safety, community, and love, I hope he's confined while they are free. I chose to come alone today because I want Randall to know how little control he holds over my family. My husband is out providing for the family that Randall chose to throw away. And my children are joyfully unaware that the appointment I had today was in a courtroom instead of coffee with a friend. I can stand here alone because the joy of the Lord is my strength. And I do not feel or fear a small manipulative man sitting before me in chains. You hold no power. Tonight, I will tuck the children that Jessica gave birth to and shortly thereafter neglected into bed, and they will squeeze my neck goodnight. They will know nothing but comfort. Will I alone carry the weight and the anxiety of disruption of Randall's selfish appeal? that he's caused our family. As a believer, I turn to scripture. Jesus said, "It is better that a millstone be tied to a person and cast into the sea than to cause a child to stumble." Those words remind us how sacred
I'm so
childhood
sorry for the
is
coughing.
and how fiercely it must be guarded. They remind us why predators cannot be allowed to roam free. They remind us why the law must act decisively. They remind us why his punishment must reflect the gravity of his crimes. Psalm 127:3 tells us, "Children are a heritage from the Lord. Offspring is a reward from him, a gift that he threw away." My children are now my heritage from God. They are a gift entrusted to me to protect and to nurture. Randall may have tried to steal that gift through abuse, neglect, and manipulation, but today it is safe in my hands. Today they are learning to thrive, to love, to trust, and to grow in a home where they are absolutely cherished. I thank God for the gift of my children and don't take that responsibility to protect them lightly. That means every appeal that he files, I will be here to speak again for the children that God has entrusted to me. Psalm 11:5 reminds us, "The Lord examines the righteous, but the wicked, those who love violence, he hates with a passion." And Proverbs 11:21 says, "The wicked will not go unpunished, but those who are righteous will go free." These words remind us that justice is God's design and that evil must face consequences. We are in the presence of evil today. Your Honor, for the sake of my children and
Guys, I'm
all
so sorry for
children,
coughing.
I ask you to impose the maximum lawful sentence at resentencing today. Keep him confined for the rest of his life. Let the consequences of his actions be permanent. Let him live in a tiny, empty space he deserves while my children continue to heal. I will not raise my children to hate anyone. He would relish in that. I will raise them to forgive when they are ready and when healing allows. As Colossians 3:13 says, "Forgive as the Lord forgave you." And I will teach them that forgiveness does not mean freedom for a predator. It simply means freedom for their own hearts. For Randall, there is still one path and only one path to hope. The Roman road reminds us that salvation is still available even to people that we think is undeserving. Because in Romans 3:23, it says, "For all have sinned and fall short of the glory of God." In Romans 6:23, it says, "For the wages of sin is death, but the gift of God is eternal life in Christ Jesus our Lord." Romans 5:8 says, "But God demonstrates his own love for this and this. While we were still sinners, Christ died for us," all of us, even the worst of us. Romans 10:9 says, "If you declare with your mouth that Jesus is Lord and believe in your heart that God raised him from the dead, then you will be saved." That is and should be the only hope for Randall Newman. Salvation with repentance, through repentance, but please, not freedom from punishment. Justice is necessary and mercy should come only through God, not through you and not through this courtroom.
Thank you, ma'am.
Now, if that can't be considered a mic drop moment right there, I don't know what can be, to be quite honest with you. That lady spoke so incredibly, just beautifully, frankly. People like that, people like this lady here are heroes in our society. So many children out there are neglected and unwanted. And as we can see from the likes of this piece of just mistreated, and children are some of the most vulnerable people in our society and they need to be protected at all costs. It's just as simple as that. There's no two ways about it. And ladies like this and her husband and her family at large are the kinds of people who stand in and say, okay, I'm going to take up that mantle. Not even just to take in a child, but to take in multiple children, especially who came from such a terrible situation. That is heroic, to give those children a loving home like that. Now, I'm not a religious person at all, but I agree with the things that she just said, 100%. Be that, from a religious text or from just our own belief and understanding, that's good enough for me. She's absolutely right in what she's saying right there. Just the whole scenario here is beyond shocking, frankly. Like, it really, really is. But people like this lady help to maybe heal those wounds a little bit for those kids. And I hope they have the best life ever. It's not going to be an easy road for anybody involved in this scenario, but I really do hope for the very, very best for all of them. All right, let's play on. It gets juicy.
For your statement and also for the home providing for those children. Ms. Goodrich, recommendations from the people.
Yes, Your Honor. Thank you. The defendant is 48 years old. He has 6 prior felonies and 6 prior misdemeanors.
Wait a minute, 48 years old? Dude looks about 290, man. Holy hell.
He is requesting the minimum statutory of 25 years. In reviewing his memo, I would ask the court to look at the fact that it was void of any information of his assaultive crimes as an adult he is engaged in. A lot of it was self-reports. I'm sure his perception of how the teachers treated him would be spoken differently by the teachers if asked. What we did learn is he has been assaultive at the early age of kindergarten when he kicked his teacher, flipping desks in his teen years, slapping his assistant principal in high school, broke a safety glass using his head in a patrol car as a teenager, and had to be removed from his home by the government because his parents couldn't control him. He talks about getting a GED in prison, but at the last sentencing, I noted that he talked about him getting a GED 6 years prior to that. As an adult, he had 3 children, one who passed away, it says in the memo. It was a strange quote that what he remembers is that she had taken a screwdriver and poked him in the butt with it. And those were the kinds of times that made him want to spend more time with her. He later caused himself to lose his parental rights on his other 2 children. He then entered a new relationship with 3 children, where he sexually assaulted all 3 of them, including his disabled child. But yet he says in his memo, we should be sympathetic or give consideration to the fact that he considers himself disabled. Attached to a psychiatric history was a statement that he misses that he can't go outside and set a car on fire. It does accurately state that he's someone who has difficulty holding down employment and struggles to maintain healthy personal relationships. While it's true, it's a statement that he misses that he can't go outside and set a car on fire. It does accurately state that he's someone who has difficulty holding down employment and struggles to maintain healthy personal relationships. While it's true, it's a significant understatement, and it's further reason why a prison sentence is appropriate. He fled to Alaska during a probationary period. He fled to Montana during this case. And the most alarming part of this memo was the disconnect between himself and the heinous acts he committed on these children. He says that he's saddened over the trauma his daughter had apparently faced. He has a statement further distancing his direct sexually assaultive actions on his daughter, showing no remorse, no accountability, or no insight, by stating, I hate that that happened to her. I wish I could be there for her now. The court previously sentenced defendant to the top end of the guidelines at 35 years, 7 months. The people asked the court to at least do that, but that there's reasons to exceed the guidelines. The guidelines do not take in consideration that this was his own daughter. The statute defines crimes against someone under 13, but his daughter was less than half that age at 4 years old when the sexual assault occurred. The defendant sexually assaulted his other 2 siblings in her presence. And the doctor testified it was one of the worst cases that she has seen. I request the court take all these factors into account, as well as the victim's statement, and sentence defendant to the maximum time allowed under the law.
Thank you, Ms. Goodrich. Mr. Newman, if you'd please stand for the court sentence. Mr. Newman, I presided over this trial, and I believe that the victim's testimony was truthful and credible, as did the jury. So you stand here today properly convicted of terrible crimes for sexually abusing your 4-year-old daughter by putting your penis in her mouth and in her anal opening at 4 years old. The doctor testified that this was among the worst cases of child sexual abuse that she had seen in her 30 years of practice. And the victim wasn't the only victim, the victim that testified wasn't the only victim here. She testified that the defendant also abused her younger siblings, including one who wasn't even able to speak at the time. So I would reiterate a statement I made at the original sentencing in this case. You, sir, have abused some of the most vulnerable in our society, and they should have looked to you for protection and support and trust. And instead, what they received at your hands was a lifetime of trauma and harm. I'm very thankful that they're in a loving family that's providing services that they need and the guidance and support that they need to have fruitful lives. But there's no doubt that you've caused permanent harm. Defendant's criminal history also shows an assaultive history and disturbing conduct while on parole. He once threatened his parole agent, and it took 6 officers to escort him to jail. In Montana, he assaulted an officer and attempted to escape from jail. He has been disruptive in more than one court hearing in the past. In short, Randall Newman is a dangerous person to be around. At the original sentencing, I imposed a sentence at the upper end of the advisory guidelines. At resentencing, we take into account all new information. We do have some additional information here. The defense has submitted a life history report and materials that does show some mitigating factors of defendant's upbringing and the trauma that he experienced of losing a child, which may have contributed to at least some of his criminal behaviors. It also shows a history of mental health issues. But even those materials, as the prosecutor noted, show a disturbing pattern of violence and danger to others. It mentions that once in kindergarten, his frustration got the best of him and he kicked a teacher. During middle school and high school, he was disruptive in school, and by his own admission, sometimes I was physical. His problematic behaviors escalated in his teen years, and he sometimes became physically aggressive, at one point throwing objects at his mother in the house. He recalled once becoming so angry at school that he flipped over a teacher's desk. In high school, he slapped the assistant principal, and when arrested by police, he tried to use his head to break the glass of the patrol vehicle. Now that, you're not today being sentenced or punished for how you behaved when you were 5 years old or a teenager. I certainly understand that. But those facts are relevant to show us that acting violently toward others and selfishly for your own benefit has been a defining feature of your life. There are some positives pointed out for his adjustment in prison. It says he gained his high school equivalency in July of 2024. However, it's hard for me to evaluate how positive that is when at the original sentencing, he insisted that he had already obtained his GED previously. Also, he's earned a culinary arts certificate in May of this year, 2025. But also, there are several misconducts that are listed in the pre-sentence report, a number of them. Some of them obviously, seem to be relatively minor, insolence or disobeying a direct order, interference with the administration of rules. But there are some misconducts that I want to highlight. Since I sent Mr. Newman to prison, he has been found to have engaged in the following serious misconducts: threatening behavior, sexual misconduct, threatening behavior.
If I may, Your Honor, I have something I'd like to say.
Substance abuse, threatening behavior, possession of stolen property, possession of stolen property, and assault and battery of a prison staff victim. These show that this defendant is still a threat both of violence and of sexual deviancy. This new information, particularly his post-sentencing serious misconducts in prison, is not taken into account in the advisory guidelines range. From the defendant's criminal history, his actions in this case, and his continuing antisocial behavior while in prison, it's clear that he poses a serious risk of harm to society. I believe that these are valid reasons for an upward departure from the advisory guidelines range of 171 to 427 months. Taking into account his continuing risk of threatening assaultive, and sexual misbehavior, this court believes that a more proportionate sentence would be the upper end of the next step-up guidelines range, which is 225 to 562 months. 562 months equates to 46 years and 10 months. Now, although at the original sentencing, I imposed a sentence at the top end of the advisory guidelines, I believe that the sentence I'm announcing today overcomes any presumption of vindictiveness. There is a presumption of vindictiveness triggered when there's a higher sentence imposed on resentencing. I don't believe that's triggered, or if it is, it's overcome here for a couple reasons. First, at the original sentencing, I imposed consecutive sentencing that amounted in practical terms to 71 years in prison. Although sentences are assessed individually for proportionality, it's a true factual statement that the defendant's overall sentence today in real terms is much shorter than his original overall sentence. But secondly, as I outlined earlier, there is new information since the original sentencing consisting of defendant's continuing, threatening, assaultive, and sexual misbehavior in prison, and the information that shows that that type of behavior has been a defining feature of his life. I also note that the Court of Appeals, when it held that consecutive sentencing, the consecutive sentencing I originally imposed in this case was improper, specifically rejected the defendant's request for a remand simply for concurrent sentencing. Rather, the Court of Appeals, citing People v. Bailey, noted that the proper remedy is resentencing. In People v. Bailey, the issue was the same. The trial court imposed consecutive sentences. And in the Bailey case, at footnote 3 on page 726, the Court of Appeals noted that on remand, quote, the trial court may impose even longer concurrent sentencing when it specifies grounds for doing so. This recognized that a longer concurrent sentence on remand is not foreclosed when the trial court has improperly originally imposed consecutive sentences. And here I believe I have explained sufficient grounds for doing so, specifically defendant's continued dangerous behavior in prison. So therefore, it's the sentence of this court that there be $1,499.19 in restitution, $136 in state costs, $130 in a crime victims assessment, $350 in court costs, which is well within a state court administrative office calculation of per case costs in the circuit. And then for counts 1 and 2, criminal sexual conduct in the first degree, victim under 13, defendant over 17. I commit the defendant to the Michigan Department of Corrections for a period of not less than 46 years and 10 months to a maximum of 60 years, with credit for 2,113 days already served. And he is subject to mandatory lifetime electronic monitoring upon parole. He's subject to SORA, as I noted, and that's already been accomplished. Mr. Newman, this is a sentence outside the advisory guidelines. I've explained my reasons for the imposition of that sentence. You are entitled to appellate review as a matter of right. If you are unable to afford a lawyer, I would appoint one to represent you on appeal, but you must file that request within 42 days after entry of the judgment of sentence if you want to appeal by right. We're going to hand you 2 copies of those appeal rights at this time. Ask you to initial one for us so we have a record that we gave it to you, and the other one is available for you to fill out if you wish to take that appeal. Anything further from the people?
No, yeah.
Anything further from the defense?
Just briefly, Your Honor.
Yes, Mr.
We object both to the vindictiveness of the sentence and the proportionality.
Yes, of course. Okay. Thank you. That's preserved for appeal.